Do you know what can hurt even worse than being physically abused? Hearing the threat, "I'll just have you deported." Well, good news. Congress has already built a legal off switch for that threat. It's called VAWA, and thousands of survivors use this off switch every single year. Stick with me. For the next few minutes, I'll show you the simple moves that allows you to ditch that abuse and keep your life here in the United States. Let me start with something that might surprise you. If you're in an abusive relationship with a U.S. citizen or a lawful permanent resident green holder, you don't have to choose between your life and your ability to stay in this country. The Violence Against Women's Act, or VAWA, was specifically designed to protect people like you from having to make that impossible choice. And it protects both women and men. I'm immigration attorney Zaira Solano, founder of Solano Immigration Law Firm, and let's begin understanding exactly what VAWA really is. VAWA stands for the Violence Against Women's Act. But here's what's important to understand right away. Despite the name, VAWA protections are not limited to women only. Men can file VAWA petitions too. The law recognizes that domestic violence affects people of all genders, and protection extends accordingly. VAWA was first passed back in 1994 and has been reauthorized by Congress several times since then. The immigration provisions were added because Congress recognized a fundamental problem. Abusers were using their victims' immigration status as a tool of control. They would threaten to have their victims deported, or they would refuse to file immigration papers for them. This left victims trapped in abusive relationships with no way out. The law changed that dynamic completely. Under VAWA, you can file what's called a self-petition for permanent residence to get a green card without your abuser's knowledge or consent. You don't need them to sponsor you, you don't need their cooperation, and you can take control of your own immigration case. Let's talk about who can file a VAWA self-petition. The law covers several different relationships, and the requirements are more expansive than people may realize. First, you can file if you're married to a United States citizen or to a lawful permanent resident who has abused you. This includes current marriages and marriages that ended within the last 2 years, as long as there's a connection between the abuse and the end of the marriage. The law recognizes that many abusive victims are forced to leave their marriages for their own safety. Second, unmarried children under the age of 21 can file a VAWA petition if they've been abused by their U.S. citizen or permanent resident parent. This includes stepchildren in certain circumstances. The law also allows children to include their own unmarried children under 21 in their petition. Third, parents can file VAWA petitions if they've been abused by their U.S. citizen son or daughter who is over the age of 21. This provision recognizes that elder abuse is a serious problem in immigrant communities. Fourth, this is crucial. You may qualify even if you're divorced. If your marriage to the U.S. citizen or permanent resident ended within the past 2 years and there's a connection between the abuse and the divorce, you can still file for a VAWA petition. The law also includes some important protections for people whose abusive spouses lose their status. If your U.S. citizen spouse lost their citizenship due to domestic violence-related crimes, or if your permanent resident spouse lost their status, you may still be able to file under certain circumstances. What constitutes abuse? This is where I see a lot of confusion. So let me be very clear about what constitutes abuse under VAWA. The law recognizes that domestic violence takes many forms, and physical violence is not just one of them. Battery and extreme cruelty are the legal standards, but the extreme cruelty is interpreted very broadly, and it includes physical violence, of course, but it also includes psychological abuse, emotional abuse, sexual abuse, and economic abuse. The Board of Immigration Appeals has recognized that extreme cruelty can include threats, intimidation, controlling behavior, isolation from family and friends, and destruction of property. In matter of RA, the board clarified that the abuse doesn't have to be severe to qualify. What matters is the cumulative effect of the abusive behavior on the victim. Even if behaviors that might seem minor when looked at individually can constitute extreme cruelty when they're part of a pattern of control and intimidation. I often tell my clients, if you're constantly walking on eggshells, if you're afraid of your spouse's reactions, and if they control your money, your movements, your contact with other people, that's likely extremely cruel under VAWA. The law was written to protect people in these situations. Let's talk about what evidence you need to support your VAWA petition. The government requires evidence in several categories, and I want to talk you through each one so you understand what you're building towards. First, you need to prove the qualifying relationship. If you're married, you need your marriage certificate. If you're divorced, you need the divorce decree and evidence to connect the abuse and the end of the marriage. For a parent-child relationship, you need a birth certificate or other document establishing the family relationship. Second, you need to prove your abuser's status as a U.S. citizen or lawful permanent resident. This can be a birth certificate, a naturalization certificate, or permanent resident card. Sometimes we can use other documents like passports, voting records if the primary documents are not available. Third, you need evidence of the abuse. This is often the most challenging part of the case, but there are many types of evidence that can work. Police reports are excellent evidence, but they're not required. Everybody thinks they are. Medical records, photographs of injuries, witness statements from friends or family members or coworkers, and statements from counselors or social workers can all be powerful evidence. The courts have recognized that abuse often happens in private, so direct evidence may not always be available. In matter of LR, the Board of Immigration Appeals emphasized that VAWA cases should be evaluated based on the totality of the evidence, not on any single piece of proof. Fourth, you need evidence that you're a person of good moral character. This typically means a clean criminal record, but the law recognizes that abuse victims sometimes have arrests or convictions related to their abuse. There are waivers available for certain crimes that were connected to the abuse you suffered. Finally, you need to show that you qualify for an immigrant visa and are admissible to the United States. This involves background checks and sometimes requires waivers for certain grounds of inadmissibility. Let me walk you through what the actual filing process looks like. Understanding this timeline can help you plan and prepare for what's ahead. You'll start by filling Form I-360, which is the petition for a special immigrant. This form goes to USCIS along with all your supporting evidence. There's no qualifying fee for VAWA petitions, which is important because many abused victims don't have access to money. Once USCIS receives your petition, they'll send you a receipt notice. This is an important document because it proves you have a pending VAWA case. Keep this safe because you may need it for other benefits. USCIS will interview your case and may request additional evidence if they need more information. This is normal and doesn't mean that your case is in trouble. It just means they want to make sure they have everything they need to make a decision. If your petition is approved, you'll receive an approval notice. This approval gives you several important benefits immediately. You become eligible to apply for a work authorization, you may qualify for certain public benefits, and you're protected from deportation based on your abuser's actions. After your I-360 is approved, if you're already in the United States, you can file Form I-485 to adjust your status to become a permanent resident and get a green card. If you're outside the United States, you'll go through consular processing at the U.S. Embassy or consulate in your country to get your green card. One of the most important things to understand about VAWA is the special protection it provides throughout the process. These protections were built into the law because Congress understood the abuse victims are in uniquely vulnerable situations. First, there's a confidentiality provision that's absolutely crucial. USCIS cannot share information from your VAWA case with your abuser. They can't tell your abuser that you filed, what evidence you submitted, or whether your case was approved or denied. This protection extends to other government agencies as well. The only exceptions to this confidentiality rule are very limited. Information can be shared if it's necessary for national security or if there's a court order in a criminal case. But your abuser cannot simply request information about your case. Second, VAWA provides protection against deportation in many circumstances. If you have a pending VAWA petition, immigration authorities generally cannot use your information provided by your abuser to start deportation proceedings against you. This prevents abusers from weaponizing the immigration system against their victims. The law includes provisions for derivative beneficiaries. If you're filing a VAWA petition, you may be able to include your unmarried children who are under 21 years old. This means they can get protection too, even if they were not directly abused. Let me talk about something that's often a game changer for VAWA petitioners: work authorization. Once your VAWA petition is approved, you become eligible to apply for employment authorization. This can be filed on Form I-765, and there's no filing fee for VAWA-based work permit applications. Getting work authorization can be transformative because it gives you economic independence from your abuser. You can get a social security number, open bank accounts in your own name, and start building a life independence away from your abusive relationship. The work authorization is initially granted for 1 year, but it can be renewed as long as your case is still pending or if you're waiting to apply for adjustment of status. Additionally, VAWA approval may make you eligible for certain public benefits that are normally restricted for immigrants. The specific benefits vary by state, but they can include things like housing assistance, food assistance, and healthcare programs. These benefits recognize that abusive victims often need additional support as they rebuild their lives. In my practice, I see certain challenges come up repeatedly in VAWA cases, and I want to address some of those common ones with you so you know what to expect. One challenge is gathering evidence, especially when the abuse was primarily psychological or emotional. Many clients worry that they don't have enough proof, but remember that the law recognizes many different types of evidence. Personal statements can be very powerful, especially when they're detailed and specific about the abuse experience. Another challenge is dealing with the emotional impact of documenting the abuse. Going through evidence and writing about what happened can be traumatizing. It's important to have support during this process, whether that's from a counselor, a support group, trusted friends or family, or your attorney and legal team. Some clients worry about retaliation from their abuser if they file a VAWA petition. While the confidentiality protections are strong, it's still important to have a safety plan. If you're concerned about your safety, reach out to local domestic violence organizations who can help you develop comprehensive safety plans. Language barriers can also be a challenge. All the forms and legal documents are in English, and the legal concepts can be complex even for native English speakers. Working with an attorney who speaks your language or who works with qualified interpreters can make a huge difference in your case. VAWA cases involve complex legal standards and require careful preparation of evidence. While it's theoretically possible to file a VAWA petition all on your own, having experienced legal representation significantly improves your chances of success. An attorney can help you understand whether you qualify for VAWA protection, assist you in gathering the right evidence, and present your case in the strongest possible way. We know how to address potential weaknesses in a case and how to present evidence in a way that meets the legal standard. Perhaps most importantly, an attorney can help you navigate the emotional challenges of the process while keeping your case moving forward. We understand the trauma that brings people to VAWA cases, and we know how to handle these cases with the sensitivity that they require. If you've been listening to this and thinking VAWA might apply to your situation, I want you to know that taking that first step to seek legal help is often the hardest part, but it's also the most important step you can take towards building safety and independent life for yourself and your children. VAWA exists because Congress recognized that no one should have to choose between their safety and their ability to remain in the United States. These protections are real, they're substantial, and they can change your life. The process isn't always easy, and it does require courage to document what you've been through and to take legal action. But thousands of people have successfully used VAWA to escape abusive relationships and build new lives for themselves. You have that same opportunity. Remember, your abuser cannot control your immigration status anymore. VAWA gives you the power to take control of your own case and your own future. That's exactly what the law was designed to do. Now that you understand how VAWA can protect abusive survivors and provide a path to permanent residence to a green card, you're probably wondering about other options that might be available. What if your situation doesn't fit into the VAWA requirements exactly, but you're still a victim of a serious crime? What if you've been trafficked or forced into labor or forced into commercial sex? That's exactly what I'm going to cover in my next video. What is a T visa? Exact steps for survivors to stay in the United States. T visas provide protection for victims of human trafficking, and the requirements and process are completely different from VAWA in many important ways. If you've been forced to work against your will, if you've been held in debt bondage, or if you've been compelled into performing commercial sex, a T visa might be the protection that you need. Understanding all your options is critical to choosing the right path forward and protecting your rights. I'll walk you through the T visa requirements, the application process, and how it compares to other forms of relief. These are tools that can literally save your life and give you a future in the United States. Don't wait to learn about these protections. Your safety and your legal status may depend on understanding all of the options available to you. See you there.